The police in Australia have powers to stop and search people in certain circumstances, and almost no one outside the industry knows properly when the police can stop and search you and what their rights are if that does happen. My name's Alex. I was a police officer for 12 years and now I'm a criminal defence lawyer. I've exercised all of these search powers against people, and now I defend the people charged with offences when things are found. Let's start with the major or most common search powers, what they are, and then dive into specifically how you can protect your rights and ensure that the police are doing the right thing if you are stopped and searched. This advice is relevant to Victoria, but the general tips and reasons for searches are broadly applicable Australia-wide. And as a disclaimer, this isn't legal advice. If you need legal advice, speak to a lawyer. The number one most common reason police search people is consent. If the police ask if they can search you and you say yes, then they can search you. If they ask if they can search your car and you say yes, they can search your car. If the police ask if they can search a house and an owner or occupier of the house says yes, then they can search the house. Even if it's your house and you don't want them searching, if an occupier says yes, they still might lawfully be allowed to search the house. Police will always try to search you this way first. If you agree to a search, there can be no arguing about the lawfulness of the search or if they are allowed to do it. The police are guaranteed safe if you were okay with it. Often people think it's better to agree to a search or they'll look guilty and it'll give the police a reason to search. We'll discuss this in more detail later, but the most important thing to know is that if the police ever ask if they can search you, then you should never consent. You should clearly and politely decline. Say something like, "I do not consent to a search of myself or my property." Refusing a police request for a consensual search is not grounds for the police to rely upon to search you pursuant to another search power. The number two most common type of search is what's called a safety and evidence search, and it's exercised according to common law whenever someone is arrested, either for an offence or an outstanding warrant. The police will conduct what they call a safety and evidence search, which is basically exactly what it says on the tin. The police are searching you for what they will say is their safety and yours, to ensure that you don't have any weapons or other dangerous items on you, for instance, medicine that you might attempt to overdose on, and evidence in connection to what you've been arrested for. This type of search will be conducted wherever you've been arrested. If it's in the street, you'll be searched in the street. If it's your house, you'll be searched at your house. And it's nearly always a pat-down search by a police officer who'll search you and any bags you might have. It's important to know that this search power can only be used by the police if you've been arrested, and it can occur anywhere, in a public place, private property, wherever you've been arrested. The police also cannot search your vehicle or your house using the safety and evidence search, only you and any bags that you might have on you. Next up are drugs and weapons search powers. We'll discuss these two together, even though they're separate search powers, because they have a lot of overlap and, apart from relating to different things, are broadly the same search power. The police have the power to search you for drugs, according to the Drugs, Poisons, Controlled Substances Act, or weapons, according to the Control of Weapons Act. These search powers are enlivened or activated if the police reasonably suspect that you have either illicit drugs or weapons on you. Unlike a safety and evidence search, drugs and weapons searches can only occur in a public place. However, these search powers extend to permitting the police to be able to search your car, or less commonly, your boat or your airplane as well. There's a bit more nuance to the law with this one, and important things to know is that to exercise this power, the police must suspect on reasonable grounds that you have drugs or weapons on you. So what does suspect mean? It has two elements. The first is that the suspicion must have been actually held. That means it's a subjective element, held by the police officer exercising the power, and they must have genuinely suspected that you had whatever on you and need to be able to prove it. The second element is objective. It means that the circumstances must have been of a kind that would raise a suspicion in the mind of a reasonable person. It's not enough to show that the particular police officer had the suspicion, but would a reasonable person also have had that same suspicion in the same circumstances? Well, what's suspicion? It's a positive or actual misapprehension or mistrust. It requires more than mere idle wondering. Suspicion can arise in a number of ways. A very common and obvious one is if the police see a bong in a car and can smell the odour of marijuana, that's likely to give rise to a reasonable suspicion to conduct a drug search. There is no strict legal definition setting out exactly what it means, but rather courts will take into account the various elements known to the police officer at the time that they conducted the search or formed the suspicion to decide whether the test was met. The fourth type of search is what's called a declared or designated area search. This could be an entire video in itself. The basics are that in certain circumstances, the police can declare or designate an entire area to be a search area and, without a warrant, without even suspicion, can search anyone that is in that area. You don't need to have done anything other than simply be inside the designated area at the time. Designated areas are almost always signposted with signs at the points of entrance, but of course you might not notice a sign if you're walking in, or you might go in an entrance where there's not a sign and find yourself inside a designated area. Important things to know for designated area searches is perhaps number one, that for planned designated areas, you can find the locations on Victoria Police's website or in the Government Gazette, which is available online. But you should also know that it's possible that the police can conduct unplanned designated area searches as well. And the final search power that we're going to discuss here is warrants. Police can apply to courts, or in some cases senior police officers, to authorise warrants permitting the police to search specific places, like specific addresses, vehicles, or defined private property areas for specific things. That again is a whole different video. Suffice to say that if the police are searching you pursuant to a warrant, you should ask for a copy of the warrant at the time the search is executed. You'll likely be arrested or detained by the police while the search is underway, and if this is applicable to you, you should seek legal advice as soon as you possibly can. There's other ways the police can search you that we don't have time to cover in this video, and they're less common. Examples of things like this are firearms prohibition orders, search powers pursuant to the Family Violence Protection Act, and others. However, these are heaps less common than the ones we've discussed. So what are the most important things that you need to remember? Number one, do not consent to a search, regardless of the situation, regardless of what's happening. If the police ask you, do you mind if we search? Can we have a look? The answer is always no. Even if the police don't ask you if they can, make sure that you state calmly, clearly, and politely that you do not consent to a search. You should also be aware that if the police tell you they are exercising a power to search, don't stop them, don't impede the search, don't argue or fight with the police. Doing any of that will only make your situation worse, and it won't prevent the search, and it may possibly lead to more charges. State clearly you don't consent, but otherwise don't interfere with the police search. If there are grounds to argue the validity of the search, that can be done down the line at court, either by yourself or your lawyer, and if you think your rights were violated, you can pursue that claim later down the line. Arguing and fighting with the police is never the right decision to make, and it only ever makes things worse. Make sure if the police have body-worn camera footage that it's on. If it's not, request that it is. When the police have left, make notes, sign and date them of exactly what happened. Get the details of the police officers who searched you, their name, rank, registered number. And if you're being searched pursuant to a drugs or weapons search power, ask the police to state clearly what the grounds are for why they're searching you, what their suspicion is. If you or someone you know has been charged with a criminal offence in Victoria, or is being investigated, or is a party to an intervention order and you need legal advice, you can get in touch with me via the link below. I'm Alex Loftgood, and I'll see you in the next video.